the defendant enticed and groomed girls who were as young as 14 years old for sexual abuse by Jeffrey Epstein, a man who she knew was a predator with a preference for underage girls. The indictment alleges that the defendant participated in some of these acts of abuse herself, including sexualized massages in which the victim was sometimes partially or fully nude. She also encouraged these minors to engage in additional acts of abuse with Jeffrey Epstein. The indictment makes plain, Your Honor, this was not a single incident or a single victim or anything isolated, but instead it was an ongoing scheme to abuse multiple victims for a pattern of years. This is exceptionally serious conduct. Given the strength of the government's evidence and the serious charges in the indictment, there is an incredibly strong incentive for the defendant to flee. An incentive for her to become a fugitive, to avoid being held accountable, and to avoid a lengthy prison sentence. The history and characteristics of the defendant underscore the risk of flight that she poses. The pretrial services report confirms that the defendant has been moving from place to place for some time, Your Honor, and most recently, it appears that she spent the last year making concerted efforts to conceal her whereabouts, while moving around New England, most recently to New Hampshire, which I'll discuss momentarily with respect to that particular property.
There's one assertion in the defense papers that I don't think I've seen the government's response to, and that's the contention that Ms. Maxwell, through counsel, kept in touch with the government since the arrest of Mr. Epstein. Is that accurate? And did that include information as to her whereabouts?
Your Honor, that information did not include information about her whereabouts, for starters. And second, Your Honor, the defendant's communications through counsel with the government began when the government served the defendant with a grand jury subpoena following the arrest of Jeffrey Epstein. So it is unsurprising that her counsel reached out to the government, which is in the ordinary course when an investigation becomes overt. The government's communications with defense counsel have been minimal during the pendency of this investigation. Without getting into the substance, those contacts have not been substantial, Your Honor. And to the court's question, they certainly have not included any information about the defendant's whereabouts.
All right, go ahead.
Thank you, Your Honor. It appears that the defendant has insufficient ties to motivate her to remain in the United States. With respect to her family circumstances, she does not have children, she does not appear to reside with any immediate family members, and she doesn't have any employment that will require her to remain in the United States. But by contrast, she has extensive international ties. While she's a naturalized citizen of the United States, she's a citizen of France and the United Kingdom. She grew up in the United Kingdom and has a history of extensive international travel, and she owns a property in the United Kingdom. Your Honor, there's a real concern here that the defendant could live beyond the reach of extradition indefinitely. The government has spoken with the Department of Justice FFAs in the United Kingdom and France. With respect to France, we have been informed that France will not extradite a French citizen of the United States as a matter of law, even if the defendant is a dual citizen of the United States. And while we have been informed that there is an extradition treaty between the United Kingdom and the United States, the extradition process would be lengthy, the outcome would be uncertain, and it is very likely that the defendant would not be detained during the pendency of such an extradition proceeding. Those circumstances raise real concerns here, particularly because the defendant appears to have the financial means to live beyond the reach of extradition indefinitely. As we detailed in our briefing, Your Honor, the defendant appears to have access to significant and undetermined and undisclosed wealth. In addition to the financial information described in the government's memoranda, we note, Your Honor, that in the pretrial services report, it appears that the defendant tried initially to brush off the subject of her finances when the pretrial services officer asked her, noting that she didn't have those details. The defendant ultimately provided the limited, unverified, and questionable information that now appears in the pretrial services report. She listed bank accounts holding less than $1 million and a monthly income of nothing, $0 per month of income. In addition to the matter of her finances, the report raises other concerns about whether the defendant has been fully transparent with the court or whether she is being evasive. For example, the defendant...
Ms. Moe, you emphasize the indication on the financial report of $0 of the income. Does the government think that there's income? Is there some uncertainty as to whether that is investment income as opposed to employment income or the like? What is the reason for the emphasis on that, or to the extent it's an indication that the government finds that implausible?
Yes, Your Honor. Separate from the matter of employment, it is very unclear whether the defendant is receiving proceeds from trust accounts or an inheritance or means of another kind. It is simply implausible that the defendant simply has a lump sum of assets and no other stream of income, especially given the lifestyle that she's been living as detailed in the pretrial services report. It just doesn't make sense. Either there are other assets or there's other income. We cannot make sense of this lifestyle and this set of financials. It just doesn't make sense. And as I'll detail in a moment, Your Honor, it's inconsistent with the limited records we've been able to obtain as we've been making an effort to trace the defendant's finances. On that subject, Your Honor, the report does raise concerns about whether the defendant has been fully transparent about her finances. As one example, the defendant told pretrial services that the New Hampshire property was owned by a corporation, that she does not know the name of the corporation, but that she was just permitted to stay in the house. It's difficult to believe that that was a forthcoming answer because it's implausible on its face and very confusing. But the government has continued to investigate the circumstances surrounding the purchase of that New Hampshire property. This morning, Your Honor, I spoke with an FBI agent who recently interviewed a real estate agent involved in that transaction in New Hampshire. The real estate agent told the FBI that the buyers for the house introduced themselves to her as Scott and Jen Marshall, who both had British accents. Scott Marshall told her that he was retired from the British military and he was currently working on writing a book. Jen Marshall described herself as a journalist who wanted privacy. They told the agent they wanted to purchase the property quickly through a wire and that they were setting up an LLC. Those conversations took place in November 2019. Your Honor, following the defendant's arrest, the real estate agent saw a photograph of the defendant in the media and realized that the person who had introduced herself as Jen Marshall, who had toured the house and participated in these conversations about the purchase, was the defendant, Ghislaine Maxwell. That series of facts, which I just learned about this morning, Your Honor, are concerning for two reasons. First, significantly, it appears that the defendant has attempted to conceal an asset from the court, and that at the very least, she has not been forthcoming in the course of her pretrial services interview. And second, it appears that the defendant has used an alias, and that she was willing to lie to hide herself and hide her identity. And we discussed the additional indicia of that in our briefing, Your Honor. That raises real concern. Moreover, the defendant's claims about her finances to pretrial services to be concerning to the court for additional reasons.
I'm sorry, Ms. Moe, if I may pause you before moving on from those points. There's a basic dispute within the papers as to, I think, efforts similar to the ones you've described. Our efforts to hide from authorities, and which would certainly be an indication of risk of flight, or whether in light of the notoriety and public interest that the case generated following the indictment of Mr. Epstein, whether it was an effort to protect privacy and hide from privacy reasons. How does the government suggest that determination, factual determination, be resolved if you agree that it should? And what's your general response to the veracity of that assertion?
Yes, Your Honor. As we discussed in our reply brief, Your Honor, in our view, there's no question that these circumstances are relevant to the court's determination with respect to bail for a number of reasons. The first is, irrespective of the defendant's motive, these facts make clear to the court that the defendant has the ability to live in hiding, that she's good at it, that she's willing to do it, even if it compromises her relationships and contacts with other people. And as the information provided by the real estate agent underscores, she's good at it and that she passes. In other words, even though, as the defense claims, that she is widely known, that there is press everywhere, she was able to pass during the purchase of a real estate transaction under a fake name and not be detected. So there really can be no question that the defendant is willing to lie to hide who she is, that she can live in hiding, that she has the means to do so. All of those things should be extremely concerning to the court, Your Honor, as the court evaluates whether the defendant has the ability and willingness to live off the grid indefinitely. A year is an extremely long period of time to live in hiding undetected by the public. And so all of those things are concerning. With respect to the question of motive, Your Honor, the government submits the court need not reach that ultimate issue. But we noted, Your Honor, that there were indicia during the circumstances of the defendant's arrest that suggested that there was a motive to evade detection by law enforcement. But the bigger picture, Your Honor, is the defendant's ability to...
I was surprised that information wasn't provided until the reply brief. Was there a reason for that?
Yes, Your Honor. The government wanted to be very careful to make sure we had full and accurate information. So we were first notified about those circumstances the morning of the defendant's arrest, but I wanted to personally confer with the agent who was involved in breaching the door and verify that before including that information in a brief before the court. And that's the reason for the delay, Your Honor.
Okay, but the government has done that confirmation process and is confident of the information provided, and the basic contention there is that she resisted opening the door in the face of being informed that authorities were seeking entry, and there is a suggestion of an effort to conceal location monitoring of some type by placing a cell phone in foil of some kind. Could you explain what the government's understanding factually is, and what you think I should derive from that?
Yes, Your Honor. And with apologies, we were very careful to make sure that specific language in our briefing was accurate in consultation with the agent. So I don't want to add additional facts or speak extemporaneously about that. But in short, that is correct. That the defendant did not respond to law enforcement announcing their presence and directing her to open the door. That instead she left and went into a different room. And then separately, the details about the cell phone, as the court noted, are contained in our brief. And we submit that there can be no reason for wrapping a cell phone in tinfoil except for potentially to evade law enforcement, albeit foolishly and not well executed.
All right. Go ahead.
Thank you, Your Honor. I believe I was discussing the defendant's finances, which underscore the concern about the defendant's ability to flee and about her questionable candor to the court. We submit there are concerns there for two reasons, Your Honor. The first is that we've learned that records reflecting to client information for a Swiss bank include self-reported financial information from the defendant. In other words, when the account was opened, there were disclosures made about the defendant's finances. In those records, which are dated January 2019, the defendant's annual income is listed as ranging from $200,000 to approximately $500,000. And both her net worth and liquid assets are listed as ranging from $10 million and above. Second, as we noted in our reply, the defendant is the grantor of a trust account in the same Swiss bank with assets of more than $4 million as of last month. Bank documents reflect that the trust has 3 trustees, one of whom has the authority to act independently. One of those trustees is a relative of the defendant, and the other appears to be a close associate. Despite having put millions of dollars into this trust, Your Honor, and despite its assets being controlled by a relative and close associate, the defendant mentions it not once in her motion before the court or in her pretrial services interview. And in fact, despite the fact that the government said in its opening brief that the defendant's finances and her uncertain amount of wealth, including issues about whether her wealth was stored abroad, were of serious concern with respect to the defendant's risk of flight, the defendant's opposition does not discuss this at all. There is no mention of the defendant's finances and no effort to address those concerns whatsoever. In sum, Your Honor, the court has been given virtually no information about the defendant's possession of and apparent access to extensive wealth. The court should not take that concealment, Your Honor, we respectfully submit, as an invitation to demand further detail, but instead to recognize that if the court can't rely on the defendant to be transparent at this basic initial stage, the court cannot rely on her to return to court with relief. In short, she has not earned the court's trust. Finally, Your Honor, turning to the defendant's proposed bail package. In light of all of the red flags here, the defendant's demonstrated willingness and ability to live in hiding, her ability to live comfortably beyond the reach of extradition, her strong international ties and lack of community ties, significant and unexplained wealth, and the presumption of detention in light of very serious charges. In light of all that, Your Honor, it is extremely surprising that the defendant would propose a bail package with virtually no security whatsoever. In addition to failing to describe in any way the assets of the proposed co-signers of a bond, the defendant also makes no mention whatsoever about the financial circumstances or assets of her spouse, whose identity she declined to provide to pretrial services. There's no information about who will be co-signing this bond or their assets, and no details whatsoever. The government submits that no conditions of bail would be appropriate here. But it is revealing, Your Honor, that the defendant has both declined to provide a rigorous, verified accounting of her finances, and that she has not proposed that she pledge any meaningful security for her release. She identifies no stable residence where she could reside. Instead, she proposes, among other proposals, that she stay at a luxury hotel in Manhattan, the most transient type of residence. And it is curious, Your Honor, that the defendant offers to pay for a luxury hotel for an indefinite period, and yet does not offer to post a single penny in security for the bond she proposes. Your Honor, the defendant is the very definition of a flight risk. She has 3 passports, large sums of money, extensive international connections, and absolutely no reason to stay in the United States to face a potential significant term of incarceration. The government respectfully submits that the defendant cannot meet her burden of overcoming the statutory presumption in favor of detention in this case. There are no conditions of bail that would assure the defendant's presence in court proceedings in this case. And we respectfully request that the court detain the defendant pending trial. Thank you, Your Honor.
Thank you, Ms. Moe. And just to make explicit what is clear by the government's written presentation and oral presentation, you're not resting your argument for detention on dangerousness to the community at all. It is resting on risk of flight, correct?
That's correct, Your Honor.
All right, thank you. Ms. Moe, you've indicated that you have heard from victims who are entitled under federal law to be heard at this proceeding. Could you indicate, I think you indicated that you have a written statement and then that there is an alleged victim who wishes to be heard. Is that correct?
That's correct, Your Honor.
Why don't you begin with the written statement, and then after that you can identify, as you like, the victim, alleged victim who wishes to be heard, and my staff will unmute at that time that person so that they can be heard. Go ahead.
Thank you, Your Honor. As I noted before, Your Honor, the government has received a written statement from a victim who prefers to be referred to as Jane Doe today in order to protect her privacy. So the following are the words of Jane Doe, which I'll read from her written statement. Jane Doe wrote, I knew Ghislaine Maxwell for over 10 years. It was her calculating and sadistic manipulation that anesthetized me in order to deliver me with full knowledge of the heinous and dehumanizing abuse that awaited me straight to the hands of Jeffrey Epstein. Without Ghislaine, Jeffrey could not have done what he did. She was in charge. She egged him on and encouraged him. She told me of others she recruited, and she thought it was funny. She pretends to care only to garner sympathy and enjoys drawing her victims in with perceived caring, only to entrap them and make them feel some sense of obligation to her through emotional manipulation. She was the predator and a monster. The sociopathic manner in which she nurtured our relationship, abused my trust, and took advantage of my vulnerability makes it clear to me that she would have done anything to get what she wanted, to satisfy Mr. Epstein. I have great fear that Ghislaine Maxwell will flee, since she has demonstrated over many years her sole purpose is that of self-preservation. She blatantly disregards and disrespects the judicial system, as demonstrated by her perjuring herself and bullying anyone who dared accuse her. I have great fear that she may seek to silence those whose testimony is instrumental in her prosecution. In fact, when I was listed as a witness in a civil action involving Maxwell, I received a phone call in the middle of the night threatening my then 2-year-old life if I testified. I have fear speaking here today, even anonymously. However, I have chosen to implore the court not to grant bond for Ms. Maxwell because I know the truth. I know what she has done. I know how many lives that she has ruined. And because I know this, I know she has nothing to lose, has no remorse, and will never admit what she has done. Please do not let us down by allowing her the opportunity to further hurt her victims or evade the consequences that surely await her if justice is served. If she believes she risks prison, she will never come back. If she is out, I need to be protected. I personally know her international connections that would allow her to go anywhere in the world and disappear at a moment's notice, or make others disappear if she needs to. Your Honor, those are the words of Jane Doe.
All right, thank you. And Ms. Moe, to indicate how the victim who wishes to be heard should be recognized.
Yes, Your Honor. The government has been informed through the victim's counsel that the victim wishes to speak in her true name, which is Annie Farmer.
All right, I will ask my staff to please unmute Ms. Farmer.
Can you hear me, Your Honor?
I can, Ms. Farmer. You may proceed.
Thank you. I appreciate the opportunity to speak. I met Ghislaine Maxwell when I was 16 years old. She is a sexual predator who groomed and abused me and countless other children and young women. She has never shown any remorse for her heinous crimes or the devastating, lasting effects her actions caused. Instead, she has lied under oath and tormented her survivors. Danger Maxwell poses must be taken seriously. She has associates across the globe, some of great means. She also has demonstrated contempt for our legal system by committing perjury, all of which indicate to me that she is a significant flight risk. You may never know how many people were victimized by Ghislaine Maxwell, but those of us who survived implore this court to detain her until she is forced to stand trial and answer for her crime. Thank you, Your Honor.
Thank you, Ms. Farmer. All right. And Ms. Moe, is the government aware of any other victims who are entitled to, alleged victims who are entitled to and wish to be heard as this proceeding?
No, Your Honor. Thank you.
All right. And Ms. Moe, again, just to confirm, because there was allusion in the statements of the victims to fear and danger, the government is not seeking the court to make any findings regarding danger to the community in coming to its ultimate conclusion regarding pre-child detention, correct?
That's correct, Your Honor.
All right. Ms. Moe, anything further before I hear from Mr. Kahn?
No, Your Honor. Thank you very much.
Thank you, Ms. Bell. Mr. Cohen, you may proceed.
Thank you, Your Honor. Thank you very much for the opportunity to be heard, and also for accommodating us with regards to the briefing schedule. We appreciate that, Your Honor. Your Honor, this is a very important proceeding for my client. It is critical, and we submit, as we laid out in our papers, that under the Bail Reform Act and related case law, none of which, by the way, was discussed in the government's presentation, she ought to be released on a bail package with strict conditions, Your Honor. And frankly, in order to defend a case like this during the COVID crisis with the extent of discovery we just discussed earlier in the proceeding that's going to take the government to November to produce to us, the notion of preparing a defense with our client while she's in custody under these conditions is just not realistic. I'd also like to take a moment, Your Honor, to address a few things. As we noted in our paper, our client is not Jeffrey Epstein, and she has been the target of essentially endless media spin that apparently the government has picked up in its reply brief and in its presentation today, trying to portray her before the court as a rootless, aimless, sinister person. I do want to note before I go further, pick up on something the court said. We have a proceeding now where the government is dribbling out facts, or what they claim are facts, that they could have and should have put in their opening memorandum. So we would have had an opportunity to address them in writing before the court. That's not how this is supposed to proceed, Your Honor, and I thank you, Your Honor, for pointing that out. Each day we get
Mr. Cohen, please, by all means, you've had the reply in the time that I have as well. You shouldn't hesitate to respond to any of those facts now.
I appreciate that, Your Honor, and I'm going to proceed by proffer. I would have preferred to be able to submit something in writing, but obviously the way it was done, we were deprived of that chance. I also want to make clear that our client is not Epstein. She's not the monster that's been portrayed by the media and now the government. She's part of a very large and close family with extensive familial relations, extensive friendships, extensive professional relationships. Many of these folks are on the call today, Your Honor. Thank you, Your Honor, for making that available. They're not identified, which is something one would normally do in a traditional bail hearing, because there's a very real concern that they have, and our client has, about her safety and about her privacy and her confidentiality, as Your Honor pointed out. And as we'll see in a moment, that explains a lot of the spin the government is putting on facts in this case. Your Honor, people have received physical threats. My client has received them. Most of her cluster have received them. They've received death threats. They have been injured in their jobs, in their work opportunities, in their reputation, simply for knowing my client. That's real. That's out there. The fact that all the steps the court had to go through just to make the public access available to this proceeding is also a reality. Those are real. They're out there, and they're having a very significant impact on our client. There are folks who would normally come forward as part of the bail package, who Your Honor is aware of from the pretrial service report, who can't now, at least at this point, because of the safety and confidentiality concerns. Since last week, our firm alone and my colleagues at Hayden Morgan have been besieged with email and posts, some of them threatening. This is all very real. The government attempts to poo-poo it, to give it the back of the hand, but it's very real, and we submit it's a factor for the court to consider in its discretion. Before I go further, Your Honor, I'd like to go through the 3142G analysis. Before I do that, I would like to make one comment about the CVRA proceeding under 3771. And we understand that the court is following the statute. The statute gives alleged victims the right to speak through counsel, through the government, or directly and be heard. And we understand that, Your Honor. The question today before the court we submit is whether or not our client could be released or should be released on a condition or combination of conditions to assure her appearance. And as to that question, the presentations today do not speak They do not speak to risk of flight, and the courts have, in this circuit, have thought about and researched what weight should be given to them. There's an opinion by Judge Orenstein in the Eastern District, United States Turner from April 2005, not cited by the government, in which the court, after carefully surveying the legislative history and background of the CBOA and its interplay with the bail reform statute, concluded, in considering how to ensure that the rights are afforded, I'm cognizant that the new law gives crime victims a voice but not a veto. Of particular relevance for this case, a court's obligation to protect the victim's rights and to carefully consider any objections that victim may have never requires it to deny a defendant as release on conditions that will adequately secure the defendant's appearance. Going on to cite the Senate legislative history, that's been cited with approval of United States versus Rubin, also an Eastern District case. So we understand why the court has to follow this process, but we submit that the presentations just are not relevant to the determination before the court today. And again, we got more spin. The big fact that the government, that Ms. Lowe tried to put before you through the victim, is that supposedly someone had called during a civil action threatening the 2-year-old child. Notice how carefully that was phrased, Your Honor. It wasn't tied to Ms. Maxwell. It's more spin. So we are here to consider bail. We should consider the statute. We should consider Your Honor's guidance under the statute. So let me just put that one to side. Under Turner, that really disposes of the issue of what weight to give. Turning to the statute, Your Honor, turning to the factors, I don't want to spend a lot of time on the standard because I know Your Honor is very familiar with it. But I do want to point out that in an opening brief, reply brief, and now in an oral presentation, the government has not once directly talked the standard to Your Honor or the burdens that it has. And that the statute under 3142C says that if in the case where there's not to be released ROR, which this is not that case, the court shall order pretrial release subject to the least restrictive condition or combination of conditions. That is now read, of course, in light of 3142E, F, and G, the provisions on detention, but the law, the statute, by its structure, favors release. The Supreme Court has, and the Second Circuit have advised us that a very limited number of people should be detained prior to trial because of the statute structure. And the government nowhere mentions that. It basically acts that as if all it has to do is invoke the presumption, throw some dirt on the client, and then they're done. And that's just not the legal standard, Your Honor. They also say nothing about the burden, which was discussed in the Bonnie case, written for the Second Circuit by Judge Raggi, and also in the U.S. v. English case. And without going into a lot of detail, as the court is aware, the burden of persuasion is the government. It never shifts. The presumption can be invited and submitted is here, and then it's the burden of the government to show that the defendant is a risk of flight and that there are no conditions or combination of conditions to secure the release, which we submit they haven't done here. So let me turn, Your Honor, if I may, to the factors under 3142G. And before I do that, I also want to address some of the government's comments about the bail package. We decided that we should come before Your Honor with a package that was set out, subject, of course, to review and approval by the court. Subject, of course, to verification as to suretors by pretrial services in the court. We didn't want to just walk in and say, Judge, we should be entitled to bail, please set conditions. So what we did is we went through all the high-profile cases in this courthouse in the past several years and other cases. Cases like Madoff, cases like Dreyer, cases like Esposito, where Judge Marrero ruled in 2018 relating to an alleged member of organized crime. And we went through those cases to find the conditions that were listed under 3142C And in those cases, that would be relevant and applicable. And we believe we have listed the law. We understand that, of course, they would be subject to verification. And as we noted in our papers, and I'm noting today, if we could have a guarantee of safety, if we could have a guarantee of privacy and confidentiality, and if the court required it, we believe there are other sureties that we could provide, and perhaps other amounts of property as well. That is an issue. It's a real issue in this case. It's something the government is just avoiding, but it's real. So let me talk now, Your Honor, if I might, about the 3142G G3 factors, which are the factors relating to the history of the defendant. Government spent almost no time.
Mr. Cohen, just before you leave that, the three cases that you cited, Esposito, Dreyer, Madoff, factually, did any of those cases involve defendants with substantial international and foreign connections?
No, I don't believe they did. The cases that are relevant to that, which I was going to get to, Your Honor, are Khashoggi, U.S. v. Khashoggi, U.S. v. Bodmer, U.S. v. Hansen, and Savani itself, which I was going to get to, all of which involve defendants with substantial connections. And if I might follow up on Your Honor's question, when you take off the spin, when you take off the media, and I'm going to get to it in a moment because Your Honor is going to allow me to respond. Here's their case. Defendant is a citizen of more than one country, England and France, not exactly exotic places. The defendant has 3 passports. The defendant has traveled internationally in the past, not in the past year. There was no refutation from the government on that, and they've been all over her travel records. The defendant has resided here in the past year. He's traveled internationally, and according to the government, she has financial means. I'll get to that in a moment, Judge. But let's assume for the purposes of this discussion that she has financial means along the lines the government laid out. What do those cases teach? They teach that is something the court can and should address in the bail condition. They teach that they may require stricter bail conditions. They don't teach that means there should be no bail at all. In Savani, Second Circuit case, the allegation was that the defendants had held 2 individuals in slavery for 5 years. And they had national ties or international travel and alleged as to our client, certainly in the past year. And a bond and strict bail release was approved with strict bail conditions. In Bodmer, which was before Judge Singleton in 2004, life because she's been hiding out. Now let's think about this. She's been litigating civil cases in this courthouse and other parts of the country since 2015, denying, as she does here before Your Honor, that she did anything improper with regards to Mr. Epstein. We submit, Your Honor, that is the opposite of somebody who's looking to play. And in fact, one of the people who spoke before Your Honor is a plaintiff in one of those lawsuits, seeking millions of dollars from our client and seeking millions of dollars from a fund that's being set up. Something for the court to consider. She's also, as we mentioned, remained in the United States, even though she's known of the investigation. How could she not? It's been unbelievably public for the past year. And we've been in regular contact with the government. Now, Your Honor asked that question. Very careful question from the court, and we got a shimmy from the government in response. We've been in contact with them conservatively, because we checked last night because we thought you might ask. Conservatively, 8 to 10 times in the past year, all for the same purpose. Urge them not to bring this case. It shouldn't have been brought. The notion that experienced counsel and counsel Hayden Morgan also experienced is in regular contact with the government, would surrender their client, and they turn around and deny that to the court, and deny that voluntary surrender would and could and should have been possible here, because we submit another factor for the court to consider. So let me turn to the reply brief.
Sorry, if I may, Mr. Cohen, just want to make sure I have fully that last point. Are you saying that defense counsel indicated to the government that should there be an indictment returned, that you were seeking to arrange a voluntary surrender? Is that the contention you're making?
To be precise, we were urging them not to return an indictment and saying we were always available to speak. And frankly, Your Honor, I've been doing this kind of work for 33 years. Everyone knows what that means.
So you were implying that you were urging,
yes.
Speaking to forestall any indictment. Should there be an indictment, you were implying that you should be contacted for voluntary surrender.
Yes, of course. And the day after our client was arrested, we got a note from the government sending the application for detention addressed to us and Hayden Morgan saying, your client, Ghislaine Maxwell, was arrested yesterday. So there was no doubt that we represented her along with Hayden Morgan. There was no doubt that we were available and could have been contacted and worked this out. And there's no doubt that we were confident we would have. Let me turn to the reply brief and the effort to throw some more dirt on my client, dirt that we again submit should not be considered. Part of the governing legal standards here, the precise question before the court. We heard it today in the brief. We hear that at the time of her arrest, the agents reached the gate and they saw her through the window try to flee to another room in the house, quickly shutting the door, and that the agents were So here's the spin. It's as if the government is just sort of getting a lie feed from the media. Here's the spin given to Your Honor to try to influence Your Honor's discretion. What actually happened? As the court has said we can respond by proffer. We weren't given a chance to respond in writing. My client was at the property in the morning in her pajamas. She was there with one security guard, 2 people in the house. The front door was unlocked. All the other doors of the house were open. The windows were open. Dozens of agents came storming up the drive, creating a disturbance. My client had to hire security because of the threats to her that I've relayed before, and the protocol was when there was a disturbance to go into an inner room. Well, she did. Not running out of the house, not looking for some secret tunnel. Went in the other room, the FBI knocked down the door, which by the way was open, and my client surrendered herself for arrest. That's far from the picture painted by the government. Let me turn to another thing mentioned in the reply brief and mentioned today in an effort to sort of spin the facts, make everything look sinister with respect to my client. The government said in its opening brief, well, Judge, she's hiding. She's a risk of flight because she changed her email and phone number. That's what we heard in the opening brief. Well, what happened? Something the government, frankly, should know about because it was certainly public. Last year, in the civil litigation, in August of 2019, right around the time of the arrest of Mr. Epstein, the Second Circuit ruled that certain records in one of the civil cases should be unsealed and released to the public. That was done. There was no stay of the mandate. The mandate was issued and the documents were released. Certain of those documents were supposed to be redacted, and sometimes they were, sometimes they were not. Documents including email addresses, such as security numbers, names, phone numbers, the sorts of things Your Honor, I'm sure has to deal with all the time in these kinds of situations. Well, as it turned out, for whatever reason, and that's not an issue contagious happened, some of the documents were not redacted, and her email address was revealed. Shortly after that, she starts getting a strange email. Her phone is hacked, and she had to change emails and change the account. Now she's got a phone that has legal materials on it, corresponding with her legal counsel in civil litigation, that's been hacked. So she keeps it. Why does she keep it? Because she's in civil litigation where her obligation is to keep evidence, not destroy it, and is advised that a way to keep it from being hacked again is to put it in the equivalent of a Faraday bag, whether it be in tin foil or in the bags what they now make in briefcases. And that's it. That's all that she does. And I guarantee you, Your Honor, given the tenor of the government's presentation, that had she instead said, well, this phone was hacked, I'm just going to throw it away, the government would be standing before Your Honor today saying, aha, she destroyed evidence. That adds to his complaint. Had she put it in a safe deposit box rather than simply destroyed, they would be saying, we cracked into a safe deposit box, Your Honor. This is evidence of this flight. It just does not fit the test. It's just it. And the last point on this, Your Honor, which frankly, in some ways, is the most telling point of all. The agents do a security sweep. The security sweep of a house where there's 2 people in it. I'll put that to one side for a moment. He's talked to the security guard. Apparently now they're interviewing him multiple times because the government is dribbling out facts they clearly said. And they say to him, well, who lives in the house? Ms. Maxwell does. Okay, she lives in the house. What do you do? How do you get groceries and so forth? I go out and get them for her. So let's stop and think about this, Your Honor. The government's allegation is that the person who is aware of a criminal investigation in the United States as her counsel in regular contact with the government is remaining in a property in the United States. That's the opposite. So we think that those kinds of facts, I'm sure, Your Honor, if Your Honor decides to leave proceedings open and give us, wants to come back on some issues, I'm sure we'll have more facts figured out tomorrow, the next day, and so forth. All with the disclaimer we just learned this, Your Honor. They've been investigating this case for 10 years, Your Honor. Okay. So let me turn now to another factor that the government made argument about briefly. Two more factors under 31G3, the history and characteristics of the defendant. We heard several times that there was that detention should be warranted because there's a perjury charge. Very quickly, Your Honor, we submit this does not tilt the balance in the 3142 analysis that the court has to perform. First and foremost, the defendant is, of course, presumed innocent. And secondly, the allegation nature of the perjury, if the court has been through the indictment, is someone who denies guilt. Who says they're innocent is asked in a deposition. Did you do that? Says no. The government charges them with perjury. That is not, other than the fact that it's an indicted charge, and so entitled to the weight the court would give any indicted charge, that's all the weight. Should give. Let me turn to another factor that the government mentioned. In its presentation, both in its paper today that relates to 3142. G3, which is the defendant's financial situation. And again, when you look at the case law, which is not addressed by the government at all, this is a person who has passports that can be surrendered, who has travel that can be restricted, who has citizenship that the court could take into account, and has financial needs. Does she have the financial means that the government says she has? We doubt it, but does she have hundreds of millions of dollars like those in the Madoff and Dreier case? No. But it doesn't matter. Even if the court were to assume for purposes of today's proceeding that she has the means that the government claims she does, it does not affect the analysis. That's to be addressed in conditions, to be addressed if the court requires it through verifications and further proceedings before the court. And let me just address some of the allegations made in the government's brief about her financial situation. The government goes out and arrests our client, even though she would have been voluntarily surrendered. Arrests her the day before a federal holiday, so she spends extra time in a New Hampshire prison before being transported here. And then says, how come you don't have a full account of your financial condition? How come when pretrial services ask you about it, you can't off the top of your head explain your financial condition to them? You must be lying. Judge, sir, We've been working since our client was detained with our client, trying to access family members to put as best we could a financial picture before the court to the extent it is relevant to this application and only this application. This bail proceeding should not turn into some mini investigation of our client's finances. The government has 10 years to investigate my client. But let me address some of the specific allegations in the government's plea. They point to a sale of property in 2016. According to the government, the property was sold for $15 million. There's no secret about that. Those records are out there. Government claims our client cleared $14 million from that in 2016 and apparently has it all today, which would probably make it the first New York real estate transaction to that effect. There's been liabilities, there's been expenses. Our client has been through extensive, substantial litigation all over this country denying his claims. So we think actually the number is far less than what the government asserts. But even taking it at that number, it's a number far lower than that in Khashoggi, far lower than that in trial, far lower in many cases. And the impact of that in the court's discretion should be addressed by bail conditions. Government also says, well, she has 15 different bank accounts, and here we get some hedging language, that are by or associated with her. No detail, no explanation to the court, just more dirt. It's really 15 accounts. Well, she has 3 bank accounts that she disclosed. She believes that there were more, for example, with respect to the not-for-profit that she ran for almost a decade before she was forced to shut it down because of the issues in the media and the attention in the firestorm. So it's some number less. And if it's important to the court, we will do our best to pull it together. But under the relevant cases, it doesn't change the analysis. And let me go through the last one, Your Honor. They say in their brief that they were transfers of funds. One was a transfer of $500,000. We believe that what that is was a bond maturing. So when a bond matures, it is transferred out. And then there was another one, and the government sort of changes its mind between its opening brief and its reply brief. I'm sure by tomorrow we'll have some new speculation for the honor. But essentially, let's call it a several $100,000 transfer out of an account in June and July 2019. What does that refer to? It refers to one of the themes we've been talking about in our submission in all of today, Your Honor. When Mr. Epstein was arrested, it had all kinds of effects on our client. One of which was that the bank in question, referenced in the government's case, dropped her. But when the bank drops you, you have to transfer your funds. Out. That's true. That's what happened. So there's nothing in there that's sinister. There's nothing in there that shows an intent to evade, and nothing there that consistent with the case that warrants detention. And one last point on the financial stuff, Your Honor, before if I might. In the reply brief, we get a new allegation that a FBAR, a foreign filing was made in 2018 and 2019, disclosing that our client had a foreign bank account. Let's stop there. Our client makes a legally required filing with the Treasury Department, obeys the law, and discloses a foreign bank account, and the government is claiming that's evidence of hiding. I mean, this is all really just upside down, Your Honor. It's just these are not factors to be considered in the exercise of the discretion on the 3142. Let me turn very quickly to the other two factors that are relevant to today's purposes, because as Your Honor has pointed out, the government is not proceeding on a dangerousness ground. That's the G1 and G2 factors, the nature and circumstances of the case, and the weight of the evidence. And here I think we all, if you bear with me a moment, here one thing. Keep in mind as an observation Judge Raggi made in the Bonnie case at page 7. Where she said, the more effectively a court can physically restrain the defendant, the less important it becomes to identify and restrain each and every asset over which defendants may exercise some control in order to mitigate risk of flight. So, if and we've suggested them, but they may be modified by the court, can put in place stringent bail conditions. We don't need to have a sidelong, month-long hearing about my client's assets, which is just designed to keep her in detention. That was an observation by Judge Raggi for the Sabat. So very quickly on the nature and circumstances of the offense and the weight of the evidence. We don't think, Your Honor, this is the place to litigate legal motions. This is the bail hearing. It's not the place to litigate complex legal questions that we will be presenting to Your Honor very soon on the motion schedule. And again, we thank the court for agreeing to the schedule. But there are a few things that are worth pointing out. We believe there are very significant motions here that will affect whether this indictment survives at all or the shape of this indictment. Given the government's representation that it's not planning to supersede, would affect the shape of the entire case or any case at all that proceeds before the court at trial, if there is a trial. That is a factor that we submit the court can consider and weigh in exercising its discretion as to the weight of the evidence. And we believe there are significant motions relating to the reach of the NPA, which we're not going to litigate here before Your Honor in a bail proceeding, that are not even for closed by the cases the government does cite to you. They cite to you the, I'm going to get this wrong, the Anabi case, A-N-N-A-B. Which says, a plea agreement binds only the office of the U.S. Attorney for the district in which the plea is entered unless it affirmatively appears that the agreement contemplates a broader restriction, and that in part is going to be our argument. We will make it to Your Honor at the appropriate time. For today's purposes, it should be in the mix and evaluating the weight of the evidence, as should the points I just made about the perjury charge and we think that there are other significant legal challenges to the indictment. We also think that there are significant issues with the weight of the evidence. The government chose to indict conduct that's 25 years old, Your Honor. You'll see when we get our motions that this we think is an effort to dance around the NPA. Come into an earlier time period and a later time period. It's all tactics. It's all this is about. This case is about tactics. It's an effort to dance around the NPA. But the fact of the matter is, the government is.
Is that? I'm sorry, Mr. Collins. By that, do you mean that the time period charged is not covered by the NPA?
Right. There's going to be litigation before Your Honor about what is in the NPA, and the government we expect is going to take the position that 01 to 07 is covered and nothing else. We disagree with that, which we'll lay out for Your Honor. So what do? They decide they'll reach back and write 94 to 97 conduct. Totally tactical, Your Honor. So now we have a case where the conduct is 25 years old. No tapes, no video, none of the sort of things you would expect in an aged case that we're going to have to defend. And we are going to defend, and I think it goes to the court's consideration of the weight in the context, the only application that's before Your Honor, which is how to weigh the 3142 factors with the structure of the statute, with the guidance of the Second Circuit and the Supreme Court, which is in favor of bail on appropriate conditions. We submit that the package we laid out for the court is sufficient. But we are certainly willing, if the court deems it necessary, to leave the proceeding open, and we think we could be back to the court, I think, in a week. If there's more the court wants or there's more detail, we've just been hampered by the fact that our client has been, by design, kept in custody. And let me just give you a little flavor for that. I know we're...
Wait, Mr. Got it. I missed that last one. Could you repeat it, please?
I'm sorry. If the court needs to advised to leave the proceeding open for a week and allow us to come back if the court has concerns about the number of suretors, for example, verification information, information about financial issues. We think that now that we have some ability to breathe a little bit, that we should be able to pull this together for the court's consideration. We came forward with the best package that we could put together on a limited notice with a client who was arrested, held in custody, has been, since she came to the NBC, held in I'll call it the equivalent of layman's term of solitary confinement. There's probably a BL. Word like administrative stay or some other word they have put now. We've had a client who has been kept alone in a room, the lights on all the time, was not allowed to speak with us over the weekend at all, wasn't allowed to shower for 72 hours, had her legal materials taken away from her, only recently given back. So working with that, we've been trying to answer questions about financial situation of others, but it's very difficult, Your Honor, under circumstances that are of the government's creation, And we would be happy to
so I do want to understand that point. I think that's the by design point that you're making, and I just for clarity, I understand that there was consent to detention originally without prejudice, obviously for precisely the proceeding we're having. But it sounded like you were suggesting that her current detention was in some way by design to prevent you from providing a full picture of her financial situation. Is that the inclination you're making?
No, I'm not saying that. I'm not going that far. What I'm saying is when you have a client who you will voluntarily surrender, who's staying in the country despite an investigation, and the government instead chooses to arrest her and detain her, that limits, certainly in the early instances, your access to the client. It's complicated by the COVID crisis and the other factors Your Honor has pointed out in Stevens and Williams' behavior. And so, it's very hard for us to pull together this financial information, and we've done as quickly as we could before the court. But the notion that my client should have been able to answer off the top of her head the questions of pretrial services about a real estate transaction, for example, just doesn't make any sense. That's the point we're making.
Okay.
One last point in that regard, Your Honor. And the schedule we set today, thank you, Your Honor, for approving that, Charlie said. The government is saying that it needs at least until November to complete all discovery, including electronic discovery. They told us that that there's two investigations. There's the investigation of our client, and there's the investigation of Mr. Epstein. And there are, in the government's words, and our words together, voluminous materials. We haven't seen it yet, but voluminous, including voluminous electronic materials. the notion that we would be able in any meaningful way to review these with our client to prepare the case for motion and for trial under the current pandemic situation is just not realistic. It's not meaningful. It's not fair. And I should say, as Your Honor noted, in the Stevens case, we're not faulting the Bureau of Prisons. We're not faulting the Marshal Service. We understand they're doing the best they can under the circumstances. But this is just not realistic. You have a convict that's alleged to be 25 years old. You have extensive discovery that's going to take the government, if they hit the deadlines Your Honor said, and we all know that sometimes it doesn't happen, 4.5 months to provide. And the government wants our client to remain in custody the whole time without being able to meet with us in person, with limited access, in some form of administrative seg, apparently because they're afraid of what happened with Mr. Epstein. I don't know. It's just not a realistic way to prepare a case, particularly, Your Honor, when as we submit the conditions, combination of conditions to secure release can be satisfied under Your Honor's guidance. And in response to that, the government said, "Well, too bad, COVID crisis, too bad, Ms. Maxwell. We're not going to let you out. We're not going to let you out because you might get infected. We're not going to let you out because, because it'll be tough preparing your trial." And they cite to Your Honor in reply 2 pages of cases, very limited parenthetical. If you actually read those cases, they're totally different from our situation, Your Honor. Cases they cite on health risks in the prison environment. They cite 14 cases, 12 of them are dangerousness cases. The people who are convicted of multiple felonies, including weapons felonies, the courts in those cases determine the COVID factors do not outweigh that analysis. They cite 9 cases on the preparation and access to counsel. 7 of them are dangerous cases. And the other ones that have some discussion of flight risk are so extremely different from our cases to not be relevant. Judge, I don't know how we could possibly prepare this case, getting 4 months of discovery, including electronic discovery. I didn't go over 25 years of conduct with a client who's in custody. We can't. Meet with in person. And I'm not correcting the DOP. I understand why they have. Do what they have to do. Your Honor has made this so important. But it's just we have. To be in the real world here. We have to get out.
Whether defendants are detained because of risk of flight or dangerousness, they're still entitled to the same Fifth Amendment rights to access defense counsel. Compare their cases.
Of course, Your Honor. What my point was a more narrow point. My point is that the facts in those cases are different from our case in a meaningful way. In the court was doing a different evaluation. That was the sole point I was making in this case. So, in conclusion, We believe this is a compelling case for bail. We believe that the government, which has the burden of persuasion that never shifts, has not made it showing as required that our client is a risk of flight when you consider the risk, as Judge Raji put it in Sabani, the actual risk of flight, not fantasy and not speculation. When you consider that the only factors they really think to are ones that the cases have already addressed, such as international travel and passports. We also submit that the government has not carried its burden of showing there's no condition or combination of conditions that secure release. So we would ask the court to grant bail today, and if the court needs more information from us, we would respectfully request that the court leave the proceeding open for a week so that we can try to satisfy the court because we want to. Thank you, Your Honor, for your time.
All right, thank you, Mr. Cohn. Ms. Moe, would the government like a brief reply?
Yes, Your Honor. Thank you very much. Your Honor, I want to begin by addressing head-on the notion that the government's presentation or its case is somehow about sin or about throwing dirt or about the media. Your Honor, my colleagues and I are appearing today on behalf of the United States Attorney's Office for the Southern District of New York. Our presentation of the defendant's conduct is detailed in an indictment that was returned by a grand jury in this court. These are the facts. It is not dirt. It is not sin. That is the evidence, and that is what we have proffered to the court. And the notion that anyone could read the indictment that has been returned in this case and now reach the conclusion that an adult woman cultivating the trust of underage girls, knowing that they will be sexually abused and exploited by an adult man, and conclude that that is chilling conduct, that is on the face of the indictment, Your Honor. Turning to the facts we have proffered to the court about the defendant's finances, and particularly about the defendant's conduct in hiding, it appears, Your Honor, that it is undisputed that the defendant was living in hiding and took those actions. There cannot be any sin or characterization of this sin. Those are the facts which appear to be undisputed. Turning to several specific points, Your Honor, that I'd like to respond to. I want to address the notion that the defendant would have surrendered if the government had asked her to. And as defense counsel conceded, no offer along those lines was ever made. And of course, the government doesn't have to accept the defense counsel's representation that their client would surrender. In fact, the fact that the government took these measures to arrest the defendant reflects how seriously the government takes the risk that the defendant is a flight. Why on earth would the government notify the defendant through her counsel that she was about to be indicted and arrested if the government had serious concerns that she was a risk of flight? That is exactly what occurred here. In addition, it is interesting that the defense counsel notes that it should have been obvious to the government that the defendant would have surrendered, when at the same time in civil litigation in this district, defense counsel declined to accept service on behalf of plaintiffs who were seeking to sue the defendant in connection with some of these allegations, and they were required to seek leave of the court to serve the defendant through their counsel. Your Honor, turning to the question of the defendant's finances, there is still at this point no substantive response regarding the defendant's finances or about her lack of candor to the court significantly. And while we recognize that it appears that the defendant's extensive resources may be in complicated banking records, at a basic level, the defense argument is that she cannot remember off the top of her head just how many millions of dollars she has. That should cause the court serious concern. A bail hearing, Your Honor, is not an opportunity for the defendant to solely reveal information until the court deems it sufficient. That is not a sufficient process here. That is not appropriate. This information is coming out in dribs and drabs, and a defendant should not be in a position to slowly but surely concede as the government reveals that she has been less been candid with the court about her finances. There are serious concerns here. With respect to the notion that the defendant could just surrender her passport, there's, of course, no limitation this court could set on a foreign government issuing travel documents to a defendant or accepting her if she were to enter into that country. And finally, Your Honor, with respect to the case law the defense cited, they ignore the obvious comparator case, which is Judge Byrne's decision regarding Jeffrey Epstein, which rested both on risk of flight grounds and on dangerousness grounds. And as Judge Berman detailed, the detention was appropriate in that case on risk of flight alone. And again, that conduct was at that point significant time had passed, and Jeffrey Epstein himself was not a foreign citizen. And I think I want to respond with respect to the NPA. At this point, Your Honor, the defense has articulated no legal basis to suggest that the defendant is shielded by the non-prosecution agreement, and it simply doesn't make sense that the indictment in this case is somehow tactical to avoid concerns about the NPA when the government charged Jeffrey Epstein with conduct that fell within the scope of the time period within the non-prosecution agreement, and stated before the court in connection with bail proceedings in that matter that it is the government's strong view that that agreement does not bind this office whatsoever with respect to any kind of conduct or any kind of individual. That agreement does not bind this office whatsoever. Your Honor, in short, it is important for the court to evaluate the question of bail viewing the totality of the circumstances. The defense's argument, in essence, attempts to view each of the government's arguments as absolute. But when you review the totality of the circumstances, the defendant's extensive international ties, her conduct over the past year, her unknown finance
here.
The
So
conference call is now ending.
I guess we can hang up now.
Hey, what's up, everyone? I don't know if you guys can hear me, but sorry I was gone for a little while. I hope you guys could hear that there was no bail for her. I don't know how much of it cut in and out, but what you were just listening to was a live feed on some lady I found on Facebook. I don't know her. I don't know if she's an activist or anything like that, but basically, I found somebody who had a live feed. For those of you who didn't know, we could call in today, but there was no way to actually be there in person. Well, they had 60 people that could be in attendance in the courtroom in New York. Other than that, though, she was not in person. They were live streaming it via a live feed from her cell into the courtroom. So that's kind of weird. I've never heard of that happening before. And basically, yeah, they argued for a while. The government said that she's a threat. You know, as you guys know and have seen probably the comments, I've written about her father, Robert Maxwell, and his intelligence connections to both British and Israeli intelligence. And let me see if that's any better. And the connections between them and her family, and Whitney Webb's written about this. I know Whitney's got a new piece out on Ghislaine Maxwell on her website, maybe coming on The Last American Vagabond. I just saw that. So her family has intelligence connections. In fact, Epstein's intelligence connections were likely through her. So she is a bigger player than Epstein. But look, where we're at now, I don't know what's better, because look, they set the court date for next July 2021. So 2021, that's a year from now. She could be killed in a year. If she's there, you know, obviously, again, let's first, okay, before I get into that, let's start with some of the weird things about this case already, just like the Epstein thing. Nobody's seen a mugshot of her. Nobody's seen, you know, the perp walk people talk about. And I don't know if those are legally required per se, but generally it's something that you would see, like on a day like today, you would see a picture of somebody in the courtroom. But since she didn't appear in the courtroom, I haven't checked. I literally just walked back in the room. But maybe some of the 60 people who were in the room took a picture of her on video, but I don't even know if they would allow that, because technically, legally, you're not even supposed to record in the courtrooms at all. So what we just did might technically be illegal. So if this video disappears, don't be surprised. I would download it as soon as I hit the end button so you can listen back to it. But so my point is, we might not see any pictures of her at all, because unless the judge allowed for pictures to be taken of the video while she was on it or something like that, then we're not going to see a picture of her. So, I mean, that already is just really weird, you know, with everything going on. The other thing is putting it off for a year. Her trial is not going to happen until July 2021. So, you know, a lot of things could happen in that time. She could be killed if she does really get killed. She could be snuck away by her intelligence connections that don't want to be exposed, and things of that sort, right? The other thing is, if they do decide to let her out on bail, if they did, but they didn't. If they did, though, you know, obviously she's a flight risk. Maybe she runs away. But either way, I mean, I don't see my point. Unfortunately, guys, I don't see justice going to be served on this one. If you haven't seen my documentary, Bringing Down Jeffrey Epstein, that goes into a lot of this, I recommend doing that. Ghislaine Maxwell is a part of that. And there are other co-conspirators. You know, obviously, we heard from Annie Farmer today in court. She spoke a message, and she is the sister of Maria Farmer. Both of them went to the FBI in 1996 to try to expose this. And in recent interviews with Whitney Webb and others, she said, you know, that she heard the Rothschilds being involved, the Clintons. She said definitely that Trump was around. She didn't specifically accuse Trump of pedophilia, just to be clear, before your heads explode. But she did say Trump was around often, and that they'd seen him around and stuff like that. And so we heard from her. We also heard from another anonymous victim. And then the government was the defense for Maxwell was just trying to argue a bunch of legal bullshit about why she should be allowed to stay, even though she's got passports in other countries. She's got lots of money hidden away. We still don't know where all her money is. We still don't know where all of Epstein's money is. Still don't even know the true source of their wealth. So there's just so many things that are untangled here. And as this B. Allen says, when is Lex Wexner going to be charged? Yeah, he is another big, I think he is the top of this. And what we really need to think about is the mega group. And I also, if you go to theconsciousresistance.com, search the mega group and Les Wexner, you'll find the videos I've done on this. I've been talking about this for a couple of years before some people were even paying attention to it. And I'm glad more people are paying attention. But I was watching the Epstein documentary, by the way, last night, Filthy Rich. And I've watched that one and the other one. And these mainstream documentaries on Netflix and elsewhere they're only surface level. So they don't even, like when they do mention Wexner, for example, as B. Allen is bringing up here, they don't even talk about Wexner's connection, that he's been connected to Ohio mafia for like decades, since the 80s. He was exposed as connected to the mafia there. He also is part of what they call the mega group, which is a bunch of basically old Jewish men. I mean, it's not an anti-Semitic thing. Look it up, the mega group. Most people don't know about them. They're not really talked about that often. Of course, when Epstein got arrested, Wexner put out a statement saying that, he had severed connections with Jeffrey Epstein in 2007 because he was just so dumbfounded that Epstein had stolen $46 million from him. And maybe that's true. I doubt it. It seems like a convenient way. Everybody's got this convenient story. Trump's got me and him, I kicked him out of Mar-a-Lago and I severed my relationship with him. Once he got arrested, everybody started coming up with whatever cover story they wanted. Everybody ducked, ran and hid for cover because they didn't want to be associated with Epstein. And only people like Bill Gates and who else? Prince Andrew continued to see Epstein afterwards, and Maxwell as well. And Maxwell was, of course, at Chelsea Clinton's wedding. I mean, these people really don't give a damn. They're all connected to it. But my point is that if this does go to trial somehow, because now she's not getting bail, if somehow a year from now she's still alive and we actually get to see her, I mean, who knows if we would even see her? Who knows? I mean, guys, oh my God, I would not be surprised. I know some of y'all saw that headline from a while back, and it's satire, but I wouldn't be surprised if it happened. I wouldn't be surprised if they tell us that she dies from COVID-19 while she's in prison, because that's what her lawyers were arguing today. Is like, she should be, she should be given a leave to leave the prison because, she's at risk for COVID-19 and all this kind of stuff. And I mean, wouldn't that just be convenient if they're she got sick and she died from COVID-19? I mean, I wouldn't be surprised, but I really hope, guys, that we can riot in the streets if this woman gets killed or gets off. Or, I mean, like, this is the thing. It's if it even made it to trial, because I tend to think what 63 Connie said here, it never makes it to trial. She's going to die, or they're going to tell us she got killed. Something's going to happen, right? Or whatever, some crazy shit. Even if it did, let's put some undue faith in the justice system for a moment and say, okay, she makes it a year from now. They protect her. She's ready to whistle. She starts speaking to the feds even before they go to court, because that's the thing, is they put her on bail for a year if she is really in there, which again we have limited evidence of. I know I joined the call late today, but I did hear other people say you could hear her voice for in the very beginning of the trial. I think she had to say not guilty or something like that, so you heard her voice for a moment. But let's imagine that did go to trial, if they let her off, can we all just fucking riot in the streets? Can we burn this place down? I mean, if they're going to let pedophiles, I mean, we already know this, but I mean, I'm just saying and this is, of course, why it won't ever go to trial, because even as I was talking to a friend of mine earlier today, a little bit about this whole system, and he's not a conspiracy theorist at all. In fact, he thinks I'm kind of crazy, but slowly over time, I've got him to see things like Epstein. And so I told him, I said, it's never going to make it to, there's never going to be any justice, because look, either she got off on bail. No, she didn't get off bail. But let's say she got off on bail. She would run away. She would hide. We'd never find her again. Even though the NSA's got all these spying equipment. Oh, magically they can't find Epstein. They can't find Maxwell. I don't know why. But so that's one way justice could not be served. But then also now she got denied bail. Cool. Score one for the good guys. But then what if she dies before she gets to trial, which is a year from now, or she is murdered or killed, whatever, right? Or she escapes, some storyline along those. The point is that she doesn't make it to trial. Okay, justice won't be served then. Or if by some magic fucking miracle she makes it to the trial, they actually take her to trial, but I would imagine that they limit the public's access to that information. They try, because they don't want this to come out in court at all. Because if she really felt like, oh my God, these people, whoever she works for, Israel, MI6, CIA, whoever else, part of that cabal, they're part of whoever else, if she really thought like, oh my God, I either sing in court or they're going to kill me, if she actually made it there, she might try to tell the truth. But again, powerful people won't let her get there. Either they're going to come rescue her and get her out of there, or they're going to kill her. And, if she dies in prison, can we just burn this motherfucker down, please? I mean, I'm just saying. I know you guys love your houses. I'm not saying burn anybody's houses down. I know you love everything. But look, seriously, if we're at the point now where even normies are starting to say, oh, wow, like, yeah, my point with that story was I was telling my friend all this stuff, and he's like, well, powerful, rich people get away with things. And I said, yeah. And they're getting away with pedophilia and trafficking, and they have been, and people are covering it up. And he's just like, oh, okay. Like, that doesn't fucking drive you guys crazy? Sorry, I'm going off on a rant here at the end of this trial hearing. But I mean, I'm just saying, like, it feels like 2019 all over again. And they got Jeffrey Epstein in custody, and people are hoping and praying and wishing and believing that somehow justice will be served. And then we wake up one of these days and, well, he's dead. Here's a convenient picture for you to see. Here's another rabbit hole, by the way, if anybody wants to go down that rabbit hole. Remember that the picture of Epstein being wheeled out on the gurney the morning he killed himself, which I thought was really weird. I've never seen them wheel anybody out with their head exposed like that. And of course, being the skeptical people we are, if they didn't show that, we'd be like, well, there's no body. And then they show us a body and we're like, oh, it looks fake. So I don't really know what to think, but I just thought it was convenient. It's odd that the New York Post guy is out there. He gets a convenient photo with Epstein on a gurney, his head. Well, if you look that up, who that guy is and who he works for, it says the mega company or something like that. But it's not the mega group, but it's just weird because the mega group is who Leslie Wexner is connected to, and a lot of these powerful, rich, wealthy Jewish business magnates and the mafia back in Ohio. I mean, it's a really big rabbit hole. Again, go to my website, search Wexner or search mega group, and you'll find a couple of videos about that. But the picture, the service that this guy took the picture of Epstein, it was listed, you know, by the mega company or something like that. So it could be a connection, could be nothing. I don't know. I'm just saying the point is that these people are there. Talk to your friends today. Talk to your friends and family. Every time that these things start happening, this is an opportunity to expose the agenda, right? Because think about it. Today now, I don't know what CNN's, actually, let's do this live. Let's see what CNN's talking about real quick, just to see, is CNN even mentioning Maxwell, you know? And as for those of you who actually heard the whole thing today, I think you kind of understand why I covered trials, because if you listened, or if you just go to CNN or you go to the, you know, the mainstream sites, they're just going to tell you a 2 or 3 headline thing like, oh, Maxwell was, you know, got no bail. But you guys heard how much detail there was in that hearing. There's so much detail. There's so much information. And so this is why I like to do court reporting and break it down when I can, because they don't tell everybody all the details of what's going on and what's really happening. Okay, so this is the front page of CNN. Right there, we got Ghislaine Maxwell pleads not guilty. Okay, so they got it right there, right? Then we got some Harvey Weinstein stuff over here. Of course, COVID-19. But let's just see what they put in here. Look at this. Like, literally, look at this. It's 3-4 sentences. Ghislaine Maxwell, the one-time girlfriend, alleged accomplice. And you know how they still include this. This is such bullshit. This is horrible to the victims. Alleged. Guys, it's not alleged anymore. Shut up. It's hold on. It's not alleged anymore. These people, these women have exposed that Epstein and others were involved in this shit. Okay, she made her first appearance via a video conference arraignment. Judge Allison Nathan, I know some people were asking about the judge. There's her name if you want to look her up. She is charged with enticement and conspiracy to entice minors to travel, to engage in illegal sexual acts, transportation, and conspiracy to transport minors with intent to engage in criminal sexual activity, and 2 counts of perjury. So they don't even have an update about the no bail. Let's go search the Google CIA real quick and see if anybody does, if anybody's paying attention. Okay, so here you go. Pleads not guilty, denies bail. Okay, so we got CNBC breaking right here from AP just 7 minutes ago. Julie Brown, who was involved with the Miami Herald 14 minutes ago. So look, this is literally breaking like now in the last 7, 14, 15 minutes. I should probably put an article together and yeah. Anyways, guys, I'm going to end this video. Just wanted to show you guys, like, it's out there, but it's only on a few Twitter feeds. Most people aren't paying attention to this shit. They're not really concerned about it. They don't really care. It's up to us to expose this. Keep questioning everything. Yeah, thanks for watching. Until next time, remember, you are powerful, you are beautiful, and you are free. Peace.